Good afternoon, and thank you for joining us again on Covered and the Law. This is your legal light and help law in these trying times. I'm your host, Samson Ladi Anyanini. After the first two episodes, part 1 and 2, on the questions more on frustration of employment contracts, loss of jobs, today you have asked us to treat one other sector of the economy that is most affected. That is contracts, particularly on provision of events or event organization. We have received your letters and your views, and that's what we are doing exactly right this moment. Did you enter into a contract for an event to be organized for you? Are the event organizers saying, even though they couldn't organize the program for you, you cannot have a refund? Event organizers are being chased for monies by those who sought their services. Where does the law come in this regard? Welcome to Covered and the Law. So, the first episode, we treated job losses, and our guest was lawyer Susanna Nyampong. We bring you a recap of what happened in part 1 in respect of job losses. It became very clear that employers have rights, so do employees. There is a duty on the part of the employer to give work and pay for work done. If there is no work to generate revenue and income, there cannot be pay. This became very clear and obvious as teachers in private schools brought to fore their plight, where some of them were being laid off unilaterally without any negotiations, and their salaries were being cut. Number 2, the COVID-19 lockdown frustrated employees' ability to go to work. You couldn't go to work because the law said you can't go to work. And the employer was also prohibited from opening their businesses unless they were an essential service provider. So you couldn't go to work, and your employer could not also open his business for you to attend work unless you were an essential service provider. 3, the law of frustration affected the employer and the employee's ability to keep to the terms of the employment contract. This was no one's fault. COVID-19, the pandemic, had been declared by the World Health Organization and in Ghana declared as epidemic also by EI 61. The best approaches that were advanced and discussed, or the advice you got, was that the best approach is to negotiate with the employees and let them take paid annual leave. The labor laws of Ghana mandate a 1-month mandatory leave for every worker. If you go on the paid leave for 1 month, and at the end of the 1 month, the pandemic had not minimized or gone away, then your employer could also discuss with you to go on unpaid leave. You could go on the unpaid leave for as long as a period that is expected that work could be available, and then you come back. Again, employers could exercise the options of layoffs. They may exploit this, in which case the employer may recall the employees anytime there is work. They could also resort to voluntary redundancy. And voluntary redundancy occurs when there is a radical change in the nature of the job or organization's structure, which is no fault of the employee. It must be based on negotiations, as affected employees are entitled to some compensation. As we discussed, redundancies can attract a lot of benefits. Some people could get as much as 2 months' pay per year for the number of years they have served the company, including other benefits. Again, the employers could also exercise the option of an ordinary termination of the contract. This should be a last resort, but must be accompanied by the due notice. The law requires that you give the employee notice for 1 month if the job is that which is in, say, a month or lasts for a year and so on. In lieu of the notice, you pay a month's salary. And finally, cutting salaries imply changing the contract terms, which could be what you call a novation or a new contract. Since that is what it is, it must be based on negotiations and not unilaterally done to avoid suits over duress claims. Thank you. So here we are again. In the second week, we engaged on the topic, the justice of e-learning, fees, the pay cuts and refund. And we had lawyer Esine Okujeto. And here are our takeaways. Each situation is dealt with in accordance with the terms of the specific contract. In contract law, each party has an obligation to mitigate the effects when there is an intervening event such as COVID-19 pandemic. The schools may rely on frustration or force majeure because the contract may have been terminated, suspended, or truncated by the effects of the pandemic. But she emphasized that frustration or force majeure will not come into play where schools have found a way to perform their duty or the terms of the contract, their duty of teaching under the contract through the e-learning process. That is where there would also not be justification to unilaterally cut the salaries of the teachers who were engaged in the e-learning service. Parents and guardians have an equal obligation to perform their side of the contract by paying the fees. But as we agreed, it becomes a novation. These were terms that were not in the original contract. Therefore, negotiation is the way to go. Schools must negotiate the fees with parents and guardians because the new fees constitute additional terms in the original contract. These schools cannot rely on frustration or force majeure to cut salaries or teachers who are performing their contracts under the e-learning without negotiation, as mentioned. Generally, parents and guardians are entitled to refund of specific elements of school fees for which the service was not provided. For those of you who were asking whether you can get a refund, this was the advice. Example, feeding fees, extra classes fees, exams and boarding fees for the unexpired period of the term. You are entitled to it because you are not entitled to fees for which you did not provide the service. That is to the schools. You are not entitled to fees for which you did not provide the service. Therefore, the parents and guardians are entitled to the refund of these fees. Again, in the absence of negotiations, parents and guardians may resort to the court for damages and for compensation. Let's now go for our news round. The coronavirus pandemic has prevented countless of people from fulfilling their contracts, from event organizers, schools, to babysitters. Could all of these people be sued for breach of contract, or are they excused due to extraordinary events? What about payments made in advance? There is more in our news round.
It affected us because we had to cancel.
Oh, okay, Jennifer. Thank you very much for the call. Jennifer is one of the many people who have had to cancel their weddings because of the COVID-19. In this story, we'll be speaking to some of the allied service providers in the event organizing industry to understand how decisions like this affect their businesses. Weddings and related events are often handled by professionals who depend on them to make a living. Event organizer Lillian Boama Tewia manages Hank 2109 Enterprise. Her outfit was compelled to return advance payment for scheduled events to clients.
Our calendar was booked for almost half of the year before the pandemic hit the country. And so we've cancelled about, I would say, 10 events. And these are events that were huge. And because of the cancellation, we've had to refund part of their monies to them. And that has been a blow for us because we have employees as well that we take care of. And without a steady flow of income now, it means that the resources that we've reserved are the same ones that we are using to refund our clients as well as take care of our employees. Well, so now we've had to lay off our employees because we cannot pay them. There's no jobs at the moment. Allied services providers like disc jockeys, MCs, public address and sound renters, decorators and photographers are all locked down. Last-minute cancellation of contracts leaves individuals like young photographer Enoke J in financial limbo.
For this past 1.5 months, people have been cancelling their, all contracts have been cancelled. Some are on hold too, especially we having some projects to do, especially some advertising shows we need to do. The clients are like, they can't invest that much money because they don't know what's happening. So it is making things a little difficult for us.
Sapphire Gardens is an event space and recreational center in Kumasi. Before COVID-19, hardly did a weekend pass without one activity or the other here. The current debt situation is a far cry from the period preceding the outbreak of the pandemic. Yabrefo Ajimai is chief executive.
Every Saturday there's a wedding here, and they pay like 3,000, 4,000 for the gowns. We also have other programs that we do every month, like a corporate Friday where we gather all the corporate people in Kumasi to come here, listen to live band, and enjoy. All these programs are off. Some even came in to make a deposit, and they've even come back for their money.
Mr. Brefo had invested over $10,000 in this facility in readiness for Easter, which virtually never was.
We were planning to use them for a program during the Easter holidays, so we just acquired them. And unfortunately, when he came, this COVID came in, and you could see that the appealing of, because it's been on the sun, and if we are not careful, we are losing the investment that we've done. Together with the transfers, it will be like $15,000. They are just wasting away.
Jemfua Owusu Chow is the owner of Royal Lameta Hotel.
First, when the president announced it on the 9th, by 11th we had cancelled 41 conferences and workshops. It spanned between March and July. We've lost a lot. Not less than maybe 500,000 Ghana cedis. Not less than.
How long these businesses in the event organizing chain remain crippled or how early they bounce back depends on persistence or otherwise of COVID-19 and government response. Prince Apia reporting.
Let's now go to the case of the day. Bafo Nketia Sapong is an event organizer, and he states our case of the day.
This pandemic has really brought a very big blow to the events industry. I am into events planning and decoration. Some of us had events, upcoming events before the lockdown. We made payments and rentals. And because of this pandemic, we had to postpone. Even some people are on, some of the clients are on us to take their monies back, which it hasn't been easy because we've bought items, we've bought flowers, we've bought fabrics, we've bought so many things. We've done rentals for their weddings. So for instance, I had a wedding hosting about 300 guests. Now, people came from US and London for that same event. But it's quite unfortunate. Because of the pandemic, we have to postpone or do the 25 people event, which from 300 to 25 is a very big blow. Now the client is requesting me to bring back their money. Where am I going to get the money from? I've done my rentals and everything. So this pandemic has really brought a very big blow to the event industry. So we still plead with some of our clients who are still on our necks, calling us in that we should bring their monies, that they should please help us postpone their events. Come what may, this thing shall pass. Thank you very much.
Right. So Bafo Nketia Sapong brings up an issue that I suppose a good number of you may be familiar with, particularly if you are an event organizer. Prior to Ghana discovering its first infection in March, certainly many people had gotten themselves ready to organize an event. There were people who had planned weddings, big events, naming ceremonies, people who were also doing birthday parties, graduation, and various other celebrations, including big calendar events like music events, award events, and so on. What people normally do is to contract event organizers like Bafo Nketia Sapong so that it takes the burden off them. They pay money, and often they will pay either 50% upfront, they will pay 70% upfront. In fact, some event organizers demand the full fees upfront. Here is his difficulty. He had taken monies, some of which needed to be invested into renting, canopies. Some of it will go into chairs. Some of it will go into food. Some of it will go into music. People need to come and organize the music for the day, entertainment. He had gone ahead and made payments, part payments for some of these. And yet, this is the circumstance he finds himself. There are some of you who also sent us your issues, and we put them together in this manner. You are asking, why can't you have a refund? Because the event never occurred. Our title or topic for the discussion today is Force Majeure, Contracts at Risk. Once again, we need to emphasize what exactly constitutes the elements that will culminate into what in law is known as force majeure, and therefore render it impossible for you to get a refund, therefore make it justifiable for people like Bafo Nketia Sapong to say that they will not give your money back to you. Today, we were going to have our guest lawyer, Mrs. Ifua Gate. Mrs. Ifua Gate works with Gate & Gate, a law firm here in Accra, and she's also the president of the Greater Accra Bar Association. But let's say because of force majeure. She is not here because of some frustrating event. A little domestic accident has made it impossible for her to be here. Now, these are the things we ought to note. When we speak about force majeure in law, we are simply talking about a situation where a supervening event, it could be a supernatural event, a supervening event like a flood, a supervening event could also include COVID-19, which has been declared a pandemic by the World Health Organization. Now, because of that supervening event, which both parties to the contract did not anticipate, they did not foresee, and also do not have the skill to prevent. So one, it was unforeseeable, it was unpredictable, and number two, it was irresistible. You could not do anything about it. And once that event happens, it makes it impossible, impracticable for you to perform the terms of the contract. Contracts are entered into on a certain basis, and that is why they are upheld by the law courts. The basis is that you and I must have a certain expectation of certainty when we enter into a contract. That is rendered in the Latin terms as pacta sunt servanda. We must fulfill our part of the terms of a contract on the basis of good faith. There is what is known as the sanctity of contracts. Every contract must be respected. That is how come you can enter into a contract and expect to reap the results of the contract. Now, flip on the other side is that whilst we have this legitimate expectation of the certainty of the contract being performed, and that each party will respect the sanctity of the contract, and that if you do not respect the contract, you will be in breach of the contract. And having breached the contract, the other party who did not commit any fault will be entitled to what is known as damages in law, or can go to court, and the court will force you to do what is known as specific performance. If the contract was for the organization of an event and you fail to do it, and you are still interested in the event, even though the time has passed, you could ask the court to force the person to specifically perform the contract. That is, ensure that it comes off in the way and manner in which you agreed for the contract to be done. Or the court, depending on the circumstance, will give you a compensation, what is known as damages, for breach of the contract by the other party who did not perform their side of the contract. Now, if the circumstance that occurred is a circumstance that was, number one, irresistible, number two, it was unforeseeable, it was unpredictable, number three, it was an external event. Number three, it was an external event. And number four, that event must have made the performance of that contract impossible or impracticable. Then it becomes obvious that you cannot ask the other party for specific performance of the contract, and you cannot also ask for damages. But here is what we all have to note. Very central. It has no general application. In other words, unless the two parties have expressly provided for force majeure in the contract, you cannot rely on force majeure to say your obligations have been discharged and therefore you cannot be compelled to perform the contract. So note, there must have been an express provision in the contract stating that an event of force majeure in the nature of a health situation like the COVID-19 pandemic, when it occurs, discharges both parties from your obligations of performing the contract. So once that is not in the contract, it's not part of the terms of the contract, neither party can rely on force majeure to absolve themselves of their obligations. In fact, what that could also mean is that it may either discharge your obligations or bring you to a situation where you will renegotiate the terms. So if you do not have it as a part of your terms of your contract expressly, you cannot benefit from it. This is what happens in countries like Ghana, in the UK, which are known as common law countries. In other countries, known as the civil law countries, like Germany, like France and Italy, it is a general law of the country. So you don't need to have provided for it specifically in the terms of your contract before you can rely on it to excuse yourself of your obligations. So in those countries, as we speak, people have been excused from the duties and the obligations they have in a contract without the contract specifically saying that a force majeure event like a pandemic of the nature of COVID-19 will excuse them. In Ghana, that does not apply. So let's take a quick break here. We'll return to take your questions and answer them directly. You're welcome back. This is Covered Under Law, your legal light and help law in these trying times. Now, from the explanation I gave earlier, the direct answer that can be given to you, I'm taking your questions now, the direct answer that can be given to you, and I'm referring to the case of the day, our event planner or organizer and people like him, is this: do you have contracts that you enter written with your the parties that you provide service for? In those contracts, do you make provision for a term of force majeure? And in the provision for force majeure, do you mention specific a health situation like a pandemic or an epidemic in the nature of what has happened? If these exist, then you easily can rely on these express provisions to excuse yourself of the obligation to perform the contract, and you may not be subject to a suit to pay damages in court. I'll give a few other reasons why that will be the case. But here is one question. I'm in the same mess as the case of the day. People are calling for their money. I am a decorator in Winneba. What should I do? You didn't give us your name, but this is the circumstance. If you had a contract and there was an express term provision for force majeure, then you rely on that, you are discharged, because that term in itself in the contract will say that upon the occurrence of such an event which you do not have control over, including a supernatural, intervention, which was not foreseeable, and which makes the performance of the terms of the contract impossible, impracticable, not difficult, but impossible, then that term itself in the contract says you will not be held liable. That term itself in the contract says you shall be discharged of the obligation in the contract. So you don't have to say it. The terms of the contract have already said it for you. However, we know that in this country, and most of you doing these kind of jobs don't actually enter into a formal contract with your the people you provide service for. Therefore, in this circumstance, because we are not a civil law country where we have a law, a legislation, which you can rely on to say you are excused of your obligation, what you ought to do is to sit down with the person who contracted you. You renegotiate. You sit down and mutually agree. How much have you already expended? How much of the money that was advanced is left? Listen to the plight of this person and also act in good conscience and act in good faith. If you definitely can make some refund to the person, make a refund to the person. You need to keep your business and you need a good name so that in future people can continue to come to you for business. So if they have paid 70% in advance, how much of that money have you already put into rentals or hiring different things to be done for food provision? How much has already been expended in buying certain groceries? We have another question, but we have Gabby on the line. Hello, Gabby. Gabby, welcome to Covered and the Law. Gabby can't seem to hear me. Gabby, welcome to Covered on the Law and the Law. Okay. Gabby's, screen is frozen. Gabby, do call back and okay. Hey, hi, Gabby. Hello, Gabby. Okay, it's frozen. Let me take the next question. You say you don't identify yourself. What is the difference between frustration of contract and force majeure? And that is a very important question. Whilst the two may look alike, in one, you may come to a point of being excused of your duty because of the radical change in the terms that you have bound yourself to perform. So there may be a difficulty in the performance. In force majeure, the requirement is one of an absolute circumstance of impossibility to perform, not practicable to perform. So if you followed us, for example, in the first episode, we discovered that because the e-learning teachers had been found another alternative job and they were teaching through e-learning, the terms of the contract could be said to have been amended slightly. The terms may not have been rendered completely impossible to perform. Therefore, the employer was giving work to the employee and ought to pay the employee for the work that they were doing. The terms may have been changed, or the performance of the contract may have become onerous, but not impossible. This one says, is there any authority to buttress the point that force majeure cannot be pleaded if not expressly included in a contract? There is a lot of such available in the common law jurisdiction. Here we dealing with the circumstances to our viewers in a way broken down so that they can appreciate them. The general principles of force majeure is that there ought to be a supervening event. It could be a supernatural event. That supervening event ought not have been foreseeable. Apart from not being foreseeable, it is impracticable and renders the contract impossible, and it is irresistible. Nana joins us on Zoom. Hello, Nana.
Yes. Yes, sir.
Let's hear your question.
Yes, sir.
Okay, so let's deal directly with your Zoom.
Yeah,
don't follow through the television
for
set.
having me.
Reduce the volume on your television set and get back, and we will listen to you. So take your time, reduce completely the voice on your television set, and follow us directly on the Zoom through which you are making contact with us. Yakubu Kabiru says, if I enter a car from Damango to Busunu, but it breaks down on the way, can I ask for a refund for his inability to take me to my destination? You enter into that car in a contract that ought to be certain. And like I said earlier, the sanctity of that contract you enter must be preserved. You enter into that contract, and that driver contracts with you to take you from one destination to the other. What caused the car to break down? What sort of fault is it? Could it not have been foreseen? But once again, remember, force majeure is relied upon when it is provided for expressly. But in this circumstance, the driver ought not rely on the car breaking down in a circumstance that he could have foreseen and did not do anything about, a circumstance that he could have done something about it. Nana, I hope that we can have you clear now. What's your question?
Thank you very much, Samson. My question is, assuming I did not have the court, the force majeure, and now I've negotiated with this contractor or this person, but the person still insists that I refund all the money to him or her. What do I do? Taking into consideration that I might have spent some of the money in procuring some of the items that I would need for such an occasion. What do I do? Thank you.
Thank you very much. Once again, central. The force majeure is an external event you have no control over. It renders the contract impossible. Once you don't have an express provision in your terms in the contract for force majeure, you can sit together and negotiate. You are renegotiating the terms of the contract. That must come by a mutual process. If in this process the other party is insisting 100% refund, once you have also expended some of the money for some of the items, show the person the receipts, show the person proof of the expenses you have already made, and perhaps how much covers your service provision for that particular contract. If the person does not agree and is just being too difficult, the point is that they can only go to court. Once they go to court, you will also bring forth your justification for why you decide to pay them a refund of X amount rather than the full refund. If you are going to court, remember, they could be asking for specific performance of the contract, or they could be asking for damages. What will be the basis for specific performance and what will be the basis of damages being sought? And on the basis of each case, the court will give a decision. But you want to keep your business and you want to have a good name. So try and reach a certain, agreeable terms with this particular person. In the US, there are people who thought that airlines, who thought that they could even decide not to refund the, airfares, and that they could rather talk about rescheduling and hoping that in future they could have their clients come back and use that money for other services on a flight. They have been ordered to pay the refunds to these passengers. Yes. Yakubu, you had a question about the car breaking down in the middle of the way. I think we have dealt with that. There was another question, Johnson from Tema. Okay, I've lost. Johnson from Tema says, an act and a legislative instrument, which is supreme. Okay, so we are dealing with force majeure situations here in Ghana. An act of Parliament, if you read Article 11 of the Constitution of Ghana, it gives you the hierarchy of the laws of Ghana. And it begins with the Constitution itself. And then it follows with Acts of Parliament, and other laws follow accordingly. So open to Article 11 of your Constitution and read the hierarchy of laws in Ghana. This is on the side, not exactly directly on what we are dealing with now. But thank you for your question anyway. Let's go to the next question. Right, we can take this question and use this question to give you some education also. There's a question also that is unrelated to the topic we are discussing now. And the question is, management of my schools, my children's school, are asking parents to attend training on how to use the school's management system, which they would be using to teach and assess pupils online. Most parents on the school's WhatsApp platform have urged management to resort to online for the training, but management insists parents attend in person. Though they have assured social distancing and other safety protocols would be adhered to, management told us they have permission from the Accra Metropolitan Education Office to conduct the training in groups of 25. Are they right to do so? This is from Ya in Accra. All right. Yeah, so this is unrelated, but here is the education you can get. And it is very instructive. We, by our parliament, passed a law which is an act. It is known as the Imposition of Restrictions Act 2020, Act 10112. What this act does is to give the president power to issue orders and directives, which are known as EIs, executive instruments. And these executive instruments are binding on all of us as far as they are intended for our public safety and health, public health. And also, the law mentions defense. On the back of this law, the president has issued a number of what is known as EIs, executive instrument. The president issued EI 64 and subsequently issued EI 67 to extend the duration of EI 64. EI 64 has a provision that says that public gatherings, including workshops, including religious meetings, including conferences, are prohibited. The EI, however, gives exemption to funerals, as in burial ceremonies, not funerals, burials for 25 people. Now, don't take the 25 to mean you can have a meeting or a workshop or a conference or a wedding or whatever event for as long as you are 25 people. All of that has been outlawed until the president takes away the EI. There is an expectation that he will extend that EI today. The 25 people exemption is for burials, private burials only, not for any other thing. If you do any other thing with 25 people in a public gathering, you will be offending the law, and when you are arrested, you could go to jail. If you are found guilty, you could go to jail for 4 years minimum or 10 years maximum, or you could be paying a fine of 12,000 or 60,000 Ghana cedis. You don't want to get into that situation. We have Kweku Nkrumah on phone. Hello, Kweku Nkrumah. What's your question?
Hi, Samson. Good afternoon.
Good afternoon. Welcome to Covered in the Law.
Thank you. In situations whereby a contract was signed, let's say in November last year, and between the client and the performer, we indicated to the client that, okay, within 5 months, I should to deliver, fulfill my part. Then, after 2 months, 3 months, but in the contract, it was not indicated that whether there will be any force majeure or whatever, those underlining was not signed, was not part of the agreement.
Okay.
What happens in this situation? Because there was no indication that whether or not there will be a force majeure or not, it didn't indicate that in the contract.
Okay, thank you. Thank you. I've heard you loud and clear. Emmanuel on Zoom, what's your question? So that I can attend to you and Kweku Nkrumah. Our time is almost up.
Yeah, thank you for the opportunity. I wanted to find out, when it comes to the e-learning you spoke about, if an institution, education institution decides to go on using e-learning and does not contact the parents to know the modalities or to know what kind of technology. And when you look at the e-learning style they use, it does not match the usual classroom where the student goes to school in the morning from, let's say, 8 o'clock to somewhere 4 o'clock. Do you still stick to the initial obligation or do a renegotiation?
Thank you very much, Emmanuel. And Emmanuel, here is directly to your answer. The e-learning is not something that you provided for in the contract that you had with the school. Because of that, as Esene Okudzeto explained to us a week ago, that will be an additional term to the original contract. So once again, it comes to negotiations to agree on what should constitute the additional term. That cannot be forced on you. So that ought to be made clear. Then, Kweku, the question you asked had originally been answered. If you do not provide expressly for force majeure, your option is to sit together and deal with this matter very nicely. Right. So time is up, and I want to say thank you very much for making time with us. And we thank Mrs. Efua Gate, President of the Ghana Bar Association, Greater Accra branch. She did everything to be here, but a domestic accident that happened at the last minute did not allow her to come. Frustration, if you like, force majeure had occurred. But she's excited to be here the next time when we table another issue. Thank you all very much, and let's learn to negotiate together nicely rather than being too legalistic about the matters that happen. Thank you.